Good evening, everyone. We'll be starting the event. We expect a few more people to come, so don't be surprised if the door opens behind you and people sneak past. We hope to be able to fit them in, even if it's standing only. But my name is Florence Foster. I'm a senior project manager here at the Geneva Academy, so welcome on behalf of the Academy. Thank you for sacrificing an evening of your busy weeks to be with us tonight. This is a co-convened event between the Geneva Academy, the Women's International League for Peace and Freedom, the Quaker United Nations Office, and I need to get out the acronym because I only know ECCHR by ECCHR, the European Centre for Constitutional and Human Rights. And we have a few representatives that will introduce themselves as we go along. I will take a sidestep for this evening and let Tessa and Yvette co-convene and co-moderate this event today. You'll see me at the tail end doing a few closing remarks. So I will be, unfortunately, between you and an apéro. So we've got a few drinks and a few nibbles for you later on. So please do stay for that. A few just housekeeping things I have to tell you by regulatory sort of protocols that there are fire exits in this building. They are through these doors. So should there be an alarm, that is where you should be going. Toilets. There are two of them on this floor, on the right and on the left. Last but not least, we are recording the panel. So that's just for you to know. We will turn off the recording for the Q&A, so feel free to be candid in your remarks and your questions to the panel, and vice versa, by the way. But also that means that if you sneeze or speak, the camera will pick up and turn to you and record you. So if you be discreet in the first segment of this conversation, that would be great. And please be vocal thereafter. So this is a topic that has wrapped my attention in the last years for those who know me, and I'm absolutely delighted to continue working on this important topic. So with no further ado, Tessa, Yvette, over to you.
Thanks. Thank you so much, Flo, and thank you for hosting us as well tonight. And good evening, everyone. My name is Tessa Cerisier. I work as the Senior Advisor in the Human Rights Program of the Women's International League for Peace and Freedom. And I have the pleasure to be your host tonight with Yvette ECCHR, who's a consultant with the Quaker United Nations Office in Geneva. Over the past few years, we've seen a growing number of legal cases challenging arms transfers decisions before national courts across the world. In Australia, Belgium, Canada, Denmark, France, Germany, Italy, Spain, the US, and the UK, just to name a few. These cases are brought out of concerns that certain arms transfers carry the risk of violations of international humanitarian law and human rights law. Just last week, for example, the UK High Court heard one such case concerning the government's decision to exclude F-35 jet components from its suspension of arms exports to Israel. The UK is one of 8 countries involved in a highly integrated international defense program producing and maintaining F-35 fighter jets. In September 2024, the UK government suspended export licenses for items that might be used by Israel in its military operations in Gaza, after concluding that there was a clear risk of breaches of international law. Despite this analysis, it chose to exempt F-35 parts and components from that suspension, citing the potential disruption to the F-35 program, and I quote, its critical role in international peace and security, including NATO's defense and deterrence. Last week, campaigners took to the UK's High Court to challenge this decision.
So this case, like the others that are being litigated around the world, encapsulates several of the issues that are at the heart of today's discussion. For example, it highlights the complexity of modern, globalized, and interdependent weapon supply chains, where parts and components are sourced from multiple countries, complicating efforts to meaningfully regulate arms flows, for example, applying end-user controls. It also raises the fundamental question, how are states and private companies meeting their legal obligations to prevent arms transfers that may facilitate the commission of serious violations of international humanitarian and human rights law? And crucially, it forces us to confront a critical question. Can political and security interests ever justify arms transfers that would otherwise be prohibited under international law? Or, as the title of this panel puts it, is the arms trade in practice above the law? Above all, these cases draw our attention back to what matters most, and I insist. The devastating impact of the arms trade on people's lives, on their rights, their communities, and the urban and natural environments in which they live.
These concerns, occurring against the backdrop of intensifying conflicts worldwide, escalating global militarization and defense spending, and defiance of international law by a rising number of authoritarian governments, have led the Geneva Academy of International Humanitarian Law and Human Rights, the Quaker United Nations Office in Geneva, the Women's International League for Peace and Freedom, and the European Center for Constitutional and Human Rights to hosting this public event. So tonight we're here to discuss with our panel the role and responsibilities of states and the private sector in the arms trade, obstacles to access to justice and accountability in arms transfer decision-making processes, and the nexus between arms transfers and serious violations of international law. Speakers will also touch upon the priority areas for action identified in the Office of the High Commissioners for Human Rights' latest report on arms transfers and human rights.
And now I have the great pleasure to introduce our very distinguished panel of speakers, and we'd like to thank them for being with us to share their thoughts on these questions. Directly to my right, we have Mr. Daniel Mörkster. Daniel is a human rights officer at the Rule of Law and Democracy section of the Office of the UN High Commissioner for Human Rights, OHCHR. The Rule of Law and Democracy section has thematic responsibility within OHCHR on matters relating to arms transfers and human rights, and is tasked with the mandates given to OHCHR on the subject by the Human Rights Council. To his right, we have Dr. Hélène Tigrouja, a professor at Aix-Marseille University in France and visiting professor of public international law at the Center for International Law at the National University of Singapore. In 2025, she was elected vice chair of the UN Human Rights Committee, and she recently published her collected course at the Hague Academy of International Law of Armed Conflicts and International Human Rights Law, BRIL, and co-authored International Rights Law, a treatise published by Cambridge University Press.
And turning now to Chloe Bailey, who's online with us. I hope you can hear me well, Chloe. Chloe is a senior legal advisor at the European Center for Constitutional and Human Rights. ECCHR is an NGO based in Berlin that uses strategic litigation to hold states and non-state actors accountable to human rights abuses and violations. As part of the business and human rights team, she engages in transnational legal interventions to advance corporate accountability for human rights and environmental harms, including litigation against European arms companies. And our final speaker, Tara Van Ho, is a senior lecturer, associate professor of law and human rights at the University of Essex in the UK until June 1st, when she will join the faculty at St. Mary's University School of Law in the US. She's co-director of the Essex Business and Human Rights Project and past co-president of the Global Business and Human Rights Scholars Association. She has advised states, intergovernmental organizations, NGOs, and businesses on the human rights impacts of corporate activities in conflict and post-conflict settings. Huge thanks to all of you for being with us tonight. And so in terms of our discussion, we decided to have 2 rounds of questions with the panelists. The first round will examine more the challenges that they see from their areas of expertise on this issue that we're discussing tonight. And the second round will focus more on recommendations and avenues for action to address these challenges. And to ensure we have enough time for questions at the end, it's always a bit of a challenge, but we'll try to be quite strict on time management. So please think of your questions for the end and save them for the end. And we have a very ingenious device to let our speakers know when you're over time and you need to wrap up, and we'll use that also in the Q&A.
So let's start. Let's kick off the first round of questions on the challenges, and we'll start with you, Daniel. In March, the Office of the High Commissioner for Human Rights released its most recent report on the impact of arms transfers on human rights. I have the report here with me. It's really recommended reading. If you want to find it, you're going to look for A/HRC/58/41, 5841, key numbers to remember. And the report examines gaps with respect to the role of states and the private sector in preventing, addressing, and mitigating the negative human rights impacts of arms transfers. Could you please take us through the main challenges or areas of concern that the office has identified in the report?
Sure. Knowing we're running a tight schedule, I'll confine my presentation to highlighting a few of the concerns expressed in the report, giving a few examples of each to illustrate. So the first group of concerns relates to a lack of robust safeguards against the export of arms in circumstances that violate international law. And examples of concern include laws exempting certain transfers from licensing requirements and therefore also risk assessments, or which allow open export licenses without mandatory reassessment, periodic reassessment. And the report also expresses concern of some examples where political considerations, particularly when transferring to allied states, trump risks of violations or influence risk assessment processes. The second concern is the lack of efforts by businesses to respect human rights and IHL, consistent with their responsibilities under the UN Guiding Principles on Business and Human Rights. And if we take some of the biggest arms manufacturers, well, there are some companies that have adopted human rights statements and policies. No information was identified on references to IHL, and no information was identified on sort of downstream human rights and IHL due diligence processes. Some companies take the position instead that domestic law is the ultimate benchmark, which of course is a concern in light of the fact that domestic risk assessment processes are not always robust, and also the practice of strategic offshoring, where companies will duplicate part of their operations in jurisdictions with less rigorous regulation. The third group of concerns relate to whether states take adequate measures to prevent unlawful arms transfers by third parties. And among the concerns highlighted is, for example, the lack of efforts to regulate the private sector, impose mandatory due diligence, and also the limited efforts by states to investigate arms transfers that are contrary to international law, particularly where the transfer initially was authorized by the state itself. The last group of concerns relates to the role played by domestic courts and the extent to which individuals are able to access justice. And the report highlights three barriers in this respect. The first is a lack of transparency and limited access to information on arms export licenses, actual exports, and on risk assessments. The second relates to requirements with respect to standing. Some jurisdictions require victim status, which preclude, of course, public interest litigation, and which also could hamper efforts to prevent actual harm from occurring before the harm has occurred. And the third relates to political question doctrines and differential standards of review adopted by some courts. Some courts have interpreted the political question doctrines very broadly to exclude arms transfers decision-making from the review of courts, or when they do review, have established pretty high thresholds to overrule the assessments made by the executive branch. And so, hoping I keep in with time, that sort of sums up the main concerns.
Thank you so much, Daniel. You actually did brilliant on time. I'm genuinely positively surprised. So we're gonna move to Hélène now. Hélène, can you explain for us the connections you see between human rights and the arms transfers question in general? And also more precisely elaborate on the linkages that you see between the Arms Trade Treaty and the International Covenant on Civil and Political Rights, particularly in terms of state obligations. And can you also explain why you consider that these two fields, human rights law, and the arms trade are integrated and interrelated questions?
Thank you. Actually, I will, it's a sort of follow-up of
Yes,
the
absolutely.
report and what Daniel just said. So for everyone, the Human Rights Committee is the monitoring body of the Covenant on Civil and Political Rights. And there's nothing in the Covenant on Civil and Political Rights about arms transfer and so on. So it might be a bit surprising to invite someone from the Human Rights Committee to talk about this topic, but precisely, and I think it's very well illustrated in the report, what we see more and more is that actually the Human Rights Committee and other treaty bodies and other human rights bodies, I would say, might play a role of compliance assessment when we talk about arms transfer. So very briefly, I will try to follow the example of Daniel. Maybe 2 or 3 points taken from the practice of the Human Rights Committee. That for me show that the Human Rights Committee or other human rights body might play this compliance role when we talk about arms transfer. First, and probably we will go back to this point, states might have jurisdiction under certain conditions when there are activities on their territory, especially activities by private companies, dealing, or that might have a bad or a harmful human rights impact on the territory or outside the territory. So I will not develop this element, but I will be happy to answer questions. But the jurisprudence of the Human Rights Committee, other UN treaty bodies, regional human rights courts have clearly established these principles of states' jurisdiction over activities of private companies, in general, but of course, when we deal with arm transfer, arm trade and arms activities. So it's extremely important to keep this in mind because sometimes states use this argument that we actually talk about private companies, so they are not accountable. For the Human Rights Committee, they might be accountable based on the Covenant on Civil and Political Rights. Second point, I will just give you an overview of the rights that might be involved when we talk about arms transfer and of course, states' obligation. For the Human Rights Committee, the most important is the right to life, Article 6 of the Covenant on Civil and Political Rights. And based on Article 6, states have negative, positive obligation and substantive obligation. I'm not going to develop all the general comment 36 on the right to life, but it's the first time where the Human Rights Committee actually mentioned this question of states' accountability and states' jurisdiction in relation with this question of arm transfer or the use of arm, etc., etc. So there are many paragraphs in the general comment 36 where the Human Rights Committee elaborated on the duty to protect life with, of course, as I said, this duty to protect not only vis-a-vis public activities from public companies or public actors, but also protection vis-a-vis private companies' behaviors, I would say. Also, in the general comment, there are many paragraphs on states' accountability and jurisdiction over activity on their territory, but also outside their territory. And maybe the most important paragraph of the general comment that is, I would say, directly related to our topic is paragraph 63, sorry, where directly the Human Rights Committee insists on this element of responsibility of the state for deprivation of the right to life affected by military or other activities in a direct or reasonably foreseeable manner. And for the Human Rights Committee, what is very important is precisely this reasonably foreseeable arbitrary deprivation of life. And that in the topic we are discussing, that is where, for instance, the risk assessment will be very important. Whether or not the arbitrary deprivation of life is foreseeable for states or based on Article 6. There are many other rights of the covenant that could be also involved when we talk about arms transfer or armed activity, prohibition of ill treatment, freedom of expression, access to information, because of course there are a huge problem of lack of transparency when it's about activities, this kind of activities, but also prohibition of non-discrimination, considering disproportionate effects of arms on different groups of individual and groups of persons. And I think this is also mentioned in the report of the office. Maybe the last point I would like to discuss, and I think also you already mentioned this, states based on the Covenant on Civil and Political Rights do not have only substantive obligation, but they have also procedural obligation, access to justice, obligation to provide effective remedies. And one of the challenges, you mentioned this, Yvette, I think in your presentation, is precisely that it's extremely difficult for people to get access to courts, because even if we have this positive movement, because in many countries, at least I take the example of France, we consider, based on our administrative law, that these questions related to arms transfer, arms license, and so on, are political questions and not justiciable questions. So it's what we call in our French law, acte de gouvernement. So it means that it's impossible or it's extremely difficult to challenge before a tribunal this kind of decision to allow or not a license. So of course, based on the human rights vocabulary, it's a problem of access to justice, and it's a problem of right to a court. So I stop there, and again, it's very well written and illustrated also in the report, but here with more.
Thank you so much, Ellen.
And I will move right along to Tara. Tara, we've just heard about the ICCPR and particularly its implications for states. Now, I would like to invite you to help us to move to consider business actors and their roles and responsibilities. Can you talk to us about how the UN Guiding Principles on Business and Human Rights, the UNGPs for short, are relevant here? How do the UNGPs interact with humanitarian law, human rights law, and the Arms Trade Treaty? And what does this mean concretely for companies involved in the arms trade?
Thank you, Yvette, and thank you to the organizers for allowing me to be a part of today's discussion. To demonstrate the complexity of the answer, I just want to show you this little graph that I created this afternoon. Admittedly, I am not a mathematician, so I can't guarantee that this is an accurate size representation of each of the fields of law, but after working on these areas for 5 to 15 years at varying levels, I think this is an accurate representation of both how broad each field of law is, as well as how complex it is. And what we're going to work on today is that tiny little intersection. And you can see again, it is extraordinarily rich and deep and complex, because what we're talking about is how human rights law intersects with humanitarian law, how human rights law separately intersects with the Arms Trade Treaty, as well as the general law around disarmament and arms control, how arms control intersects with human rights, how all of it intersects with business and human rights, and it is extraordinarily complex. But business and human rights, as you see, sits firmly within human rights law. It draws on the state's existing obligation to protect, it reaffirms that obligation, and then it also affirms an obligation or a responsibility on businesses to respect human rights. And by respect human rights, we mean that businesses should do no harm. They are to take proactive measures to ensure that their operations, goods, services, and products do not actually negatively impact on human rights. Where a business has caused or contributed to an adverse impact on human rights, And I want to note that cause and contribution are not the same thing as what we talk about as aiding and assisting in state responsibility law or complicity in international criminal law. It has its own meaning to it. So where a business has caused or contributed to a harm, they are supposed to proactively provide remedies to affected stakeholders. To avoid causing and contributing, businesses are to undertake human rights due diligence. Now, human rights due diligence was borrowed from finance law, but it also has its foundation in what states are expected to do, which Elaine just set out, where you are supposed to assess realistically the risk. You're supposed to understand how has your business partner conducted itself in the past? What does that tell you about the likelihood of how it's going to conduct itself in the future? So imagine, hypothetically, you had a country invade another country in, I don't know, 2008, and then again, I don't know, in 2014. Could you, in the future, predict that perhaps in the 2020s, they will also invade a country again? Will those be accompanied by widespread and systematic violations of human rights and humanitarian law? What did they do in the past? What are the realistic risks that are associated with entering into that partnership, ensuring that that country has access to weapons that it can use in widespread and systematic human rights and humanitarian law violations in the future? Once you have undertaken the adoption of your policy and the assessment through human rights due diligence, then businesses are expected to mitigate those risks. They can do that in a wide variety of ways. They can adopt contractual clauses. But I want to be clear that contractual clauses that everyone knows are going to be broken are not adequate or effective measures to mitigate. So where's the heft behind those contractual clauses? What is expected of your business partner when they breach those contractual clauses? And how are you going to enforce that? That's going to tell us whether or not your measures in a business and human rights framework have any actual purpose to them. Are they effective? And are they limiting your responsibility at all? Or are you simply trying to shift responsibility to another actor in the hope that eventually your victims get so tired of trying to figure out who's responsible that they just give up? So that's what business and human rights does, is it adds this business aspect to what states are already expected to do. And it does sit alongside the state's ongoing obligations, both in human rights and humanitarian law and under the Arms Trade Treaty. Now, when I first started talking about this 5-ish years ago, everyone said, oh, but how can this possibly be true? Doesn't the Arms Trade Treaty just trump everything else? And my answer to that is, first of all, no, that's not how international law works. So no. And second, really no. And then third, slightly more nuanced, which is there's actually not supposed to be a conflict between the Arms Trade Treaty and business and human rights. How do I know that? The Arms Trade Treaty tells us that in the preamble where it affirms that it's supposed to help respect human rights and humanitarian law, in Article 7, where human rights and humanitarian law is supposed to influence whether or not export licenses are granted, that reaffirms the interconnectedness of the law, how they are supposed to work together. And all business and human rights does is add onto that state centricity an additional responsibility on businesses to do all of this. Now, many of the businesses, and Daniel slightly alluded to this, but I'm going to be a little bit more blunt. Many of the businesses in the arms industry are very capable of doing this throughout their supply chains and operations in every aspect of their work, except for the arms trade. And they will tell you that the arms trade is somehow particularly unique and special and is just complicated. And I'm not going to answer how uncomplicated it is or how ununique it is, but I will say that for the second round. But please trust me now, at the onset of today's talk, it's not that complicated. Like, it involves hard decisions. I'm not discounting that. It involves standing up to states. I'm not discounting that. It involves financial sacrifices at times, not discounting that. But none of that makes the arms trade unique. None of that makes it particularly special, and none of it exempts it from the rest of the system. I'm done.
Thank you. That was so provocative that I didn't want to cut you off because I like it, but we need to move on to Chloe, who I'm sure is gonna also share super interesting points. And so we're moving a bit more to the enforcement side of things with Chloe. You work a lot in litigation and including regarding state responsibility, but also business accountability. So we wanted to ask you the specific challenges you see in your practice when litigating cases related to accountability in the arms trade. I imagine we got a bit of a taste from Tara's presentation as well, but really happy to hear more from you from your practitioner's perspective.
Yeah, great. I hope you can hear me. And thanks for the invitation to participate. I'm really sorry I couldn't be there in person in Geneva in what looks like a very interesting full room. So maybe just a few words on what ECCHR has been doing in relation to arms trade accountability. So I'm in the Business and Human Rights team, and we focus on the accountability of European states and companies for violations of international law, specifically looking at the Saudi-led coalition in Yemen. So we filed cases at national level in Italy, France, and Germany. And in 2019, we and a group of other European NGOs filed a communication to the ICC that called for the opening of a preliminary investigation into the potential criminal liability of senior company and government officials from France, the UK, Italy, Spain, and Germany for complicity in war crimes for supplying weapons to the Saudi-led coalition. And what I'll focus on in my remarks is something that has already been mentioned by Daniel and Hélène, which is the problem of access to information. So I would say that generally there's a huge veil of secrecy around the operations of the arms trade. So if we look at the information that's published by European governments on arms exports, the data either in relation to licenses or exports is really aggregated. It's high level. It omits details on destination countries or the end use of the equipment. So even for us, when we're looking to build a case, understanding what weapons have been exported and when, let alone making that extra leap to identifying which arms companies are involved, is extremely challenging. And then from an evidentiary perspective, it's also very difficult to identify which specific defense material may have been used in violations of IHL. And this really requires teams on the ground who can gather this evidence in an ongoing conflict situation. So to give an example, in our Yemen cases, we have worked really closely with an NGO called Muatana, who have documented thousands of airstrikes during the conflict. But actually, it's only in one of our cases that we were able to obtain physical evidence of a specific missile that was used in an airstrike that included a component that could then be traced to a European arms company, which was RWM Italia. And then when it comes to challenging arms exports in administrative courts, so again, it's the state licensing procedure. In our experience, this is actually practically impossible without access to information on which licenses have been approved, which licenses are currently active. But we're in this situation where this information on licenses is not public. So for example, in Germany, we have had claims being rejected for being too vague or too late because licenses had already expired. And then when we have tried to request information on arms exports to make our claims more specific, this has then been refused on the basis that it's covered by exemptions. And there are a series of exemptions that are cited, but the most common ones are national defense secrets, foreign policy, trade secrets, and even in France, the professional secrecy of customs agents. And so we've tried to challenge these refusals before administrative courts. So we have an ongoing case in France. But the courts in themselves have interpreted these exemptions extremely broadly on the basis that they are necessary to safeguard the fundamental interests of the country. So I think in sum, I've actually answered maybe the sort of key question of this panel, as from our perspective, arms exports are essentially being placed outside of effective judicial control, despite the clear public interest in ensuring that weapons sales comply with international law. And then maybe to turn to the more controversial bit, I would say that there is both a political and a judicial unwillingness to deal with the arms trade, at least from our experience in the jurisdictions where we have cases. So arms companies are receiving significant state investment. They're used to advance national geopolitical objectives. And this creates a situation where economic and political interests are prevailing over fundamental rights of access to justice and freedom of the press. And at the end of the day, when we think about accountability and access to remedy, this is just a real barrier to both of those. And it really disincentivizes victims, but also NGOs from using the courts. So even though you do have NGOs like ECCHR filing these cases, it is an extremely challenging field of work to pursue. I hope I'm still in time. I'll stop there.
Yes, thank you, Chloe.
Yes, thanks, Chloe, and thanks to all the panelists for their thoughts in round one. And I think we've heard the challenges articulated pretty powerfully. So now we'll move on to round two and try to get some ideas from our panelists around recommendations or avenues for the way forward. And I'll start again with you, Daniel. So given what we've just heard in the discussion so far, and also the findings of the OHCHR report released in March, could you launch our reflections on possible avenues forward? What is important for us to keep in mind as we try to address the negative human rights impacts of arms transfers, improve compliance? What recommendations has the office OHCHR identified in its report for the way forward?
Thank you. And I think I'll start with the last bit, just also to contextualize the report recommendations a bit. So the Human Rights Council resolution requesting this report asked for a report on gaps and future steps. And so the recommendations in the report essentially follow those four gaps or concerns and that were identified, and recommends further research to identify practical measures and good practices. And that should perhaps also be read in the context of the fact that the Human Rights Council passes resolutions on this issue on a regular basis, and their upcoming resolution is due for the 59th session of the Human Rights Council this June-July. And so essentially it is a recommendation also to the Council to be mindful of these four areas in particular. And beyond that, I think most of my points would have been covered by the presentation of other speakers. For OCHR, and this is something we attempted also to highlight in the report, is that arms transfers are governed by several areas of international law that must be taken into account by states in their arms transfers governance. And they they highlight requirements on how to effectively govern arms transfers, different aspects of arms transfer, access to information, access to justice, effective remedies. And I think another one of the important points that human rights law does invite is to adopt a more sort of victim-centered, or invite greater awareness with respect to how to accommodate the justice needs of victims through the rights to effective remedies, access to justice. So I think those would be my main points. So yeah, to allow for more time for the Q&A. Thank you.
Thank you, Daniel. We're gonna go back to you, Hélène, and building on what Daniel just said, and also the previous round of comments from speakers. What would be your recommendations for states, particularly those parties to the Covenant on Civil and Political Rights, maybe, as well as for civil society on tackling some of these challenges we discussed so far?
Okay, thank you. So it's true that, as I said previously, there are many connections between the Covenant, potential connection between the Covenant and this question of arms transfer. But it is also true, and I have to admit that the topic is quite invisible in the practice of not only the Human Rights Committee, but also other treaty bodies, or only very recently raised, and of course in parallel with the work of the office. And actually it has to do with the fact that the Covenant, as other human rights treaties, are really state-centric and really based on states' responsibility, I would say customary approach to states' accountability. So it's extremely difficult actually to grasp what Tara explained in terms of complexities of what we are discussing about when private actors are involved, when extraterritorial dimensions is involved, etc., etc. So it's not an excuse for sure, but that's why also it's so recently appeared in the practice of the Human Rights Committee. And again, we are not very well equipped because the Human Rights Committee is really based on this state-centric element. So when I say that is very recently, it's not very visible in the practice of the committee, it means that there's no case law. We do not have, we do not have a decision based on an individual complaint dealing with something that has to do with arms transfer. And we only recently, the Human Rights Committee only recently raised the question in state parties dialogue. So with the US, with the UK last year, and with France also last year, precisely because we received input from civil society. Therefore, in terms of recommendation, I would have 3 very basic recommendations. So the first one would be exactly what you are doing. So creating this bridge between the different communities, because indeed, and I'm also guilty of that, but sometimes we work in silos. So the human rights community, the business and human rights community, the arms transfer communities, and we never discuss. So I think it's extremely important to mix different peoples and different experts in different also community, because we realize that we sometimes do not take the same language. So we have to stop working in silo. Second, it's also what some of you did, send more and more information to human rights bodies, treaty bodies, regional courts, and so on and so forth, because do not overestimate the knowledge of non-arms transfer experts. So it's very important also to educate traditional or classical human rights expert. And again, I really only recently learned about this topic precisely because I read some of the report you sent and the report of the office. So especially when you know that one of the states that is involved in arms transfer will be reviewed by a treaty body. And maybe, and here it's more for Chloe, in terms of litigation, but it's more a mid or long-term recommendation. It would be great to bring a case before a human rights body, so either regional court or a treaty body. So of course, I know that there's the problem of exhaustion of domestic remedies, which is a big challenge, but it would be great. So I think in terms of difficulty, the right to life, even if it's for me one of the most important rights, it might be extremely difficult to build a case based on the right to life because of the interpretation, the threshold, and so on. But maybe the easiest way would be to use freedom of expression, transparency, and access to information. And I do not say that it's easy, but I think it would be, yeah, the easiest way to start litigating at the international, regional or international level, this kind of question. So I would love to have this kind of cases before, not only for legal curiosity, but also it's a way to say to states that indeed arms transfer is a human rights question. It's also a human rights question.
I'm scribbling furiously. So now we'll turn to Tara. Many of you might be aware that the Arms Trade Treaty's informal preparatory meetings are taking place in Geneva this week to prepare for their 11th Conference of States Parties, which will take place in August. There might be some of you involved in those discussions in the room. Tara, if you had a magic lamp and you could ask for one thing from the ATT Conference of States Parties as regards the responsibilities of business or industry actors active in the arms trade, what would your ask be?
So my ask is a little controversial here, and it's please don't try to lead on this issue. I'm just going to go back to the slide. Look at how complex that is. Now, to the credit of OHCHR, they've been dealing with the vast majority of this for a very long time. Only this arms control disarmament law section is new to them. All the other complexity is old hat to them. They do it extraordinarily well. They know what they're doing. Please, 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 please let them lead on it. Because getting this wrong is to sacrifice people you have no authority to sacrifice, right? It is to sacrifice the lives of people you have no authority to sacrifice. These are complex issues. Business and human rights has worked through these issues with a lot of industries. So before, when I said the arms industry is not a special snowflake amongst all of this, I'm being serious about that. Pharmaceutical industry has to do human rights due diligence on states, who are also their regulators and also their clients. Oil, gas, and mining has to do human rights due diligence on state parties, who are also their regulators and their clients. The private military security companies have to do human rights due diligence on states parties that are also their regulators and also their clients. We have lessons learned. We know how to make this work. I'm not going to suggest that it's going to be exactly everything that the Arms Trade Treaty state parties would want, but I am going to say that it's going to be practical, it's going to be well-grounded, it's going to be well-founded. You don't have that expertise. And I say this with tremendous respect for the states parties to the Arms Trade Treaty. I say this with tremendous respect to the Secretariat. This is not the fight that we need you in. What we do need you to do is develop an effective mechanism for sharing best practices and reviewing states parties so that we understand what you're doing and how you're doing it so that you can learn from each other about how you do it. But in terms of developing sector guidance on this issue, please, 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 leave it to the experts.
Always controversial. Love it. So Chloe, we're gonna go back to you. Hélène suggested some ideas for potential litigation, individual communications. So we just want to build on that and also on your practice, and maybe if you have also ideas of other legal avenues that should be explored more. You said this is really hard work, so maybe others need also to come onto this and to help with the strategizing. But if you can share some ideas maybe of other strategic legal avenues that should be explored further.
Yeah, and I would say always open to hear new ideas and suggestions. So yeah, and on your specific points, Hélène. So yeah, looking at freedom of expression and also right to life is something that we have in mind, but not more from the perspective of the European Court of Human Rights. So actually in 2023, we filed a case against Italy at the European Court of Human Rights on the basis of violation of the right to life for sort of failure to investigate a criminal complaint that we filed a few years earlier. But I think it's definitely an interesting idea to think about more the international treaty body level. So maybe just a few thoughts from me. I think one thing that I did want to mention is human rights due diligence and mandatory human rights due diligence. specifically from an accountability perspective. So I definitely think that this is a topic that the arms trade needs to adopt and implement. But I think if we look at sort of access to remedy and access to justice, it won't necessarily provide maybe the silver bullet that we're looking for. So if you look at the legislative landscape in Europe, for example, the ECCHR, the arms trade was actually carved out from that, which is really disappointing. Especially because this is something that we at ECCHR we're really sort of pushing for its inclusion. And then if you look at existing supply chain laws, so in Germany and France, they would not really provide a very strong legal basis through which to file a case against an arms company, due to their focus on the upstream rather than the downstream supply chain. And from sort of my own personal experience, so I'm involved in a number of cases that have been filed under the supply chain laws in Germany and France, not related to the arms trade. And one of the biggest obstacles that we face is a lack of effective enforcement, and the barriers that this really places on access to remedy for victims where human rights have been violated. So maybe pivoting to some of the other approaches, I really think that it's important to continue to look at the role of criminal law, specifically complicity of companies in international crimes. So I think it's important to note that even if a company carries out human rights due diligence, this doesn't exclude the possibility that individual corporate managers could be found criminally liable if a company continues to export weapons with the knowledge that they would be used in the commission of international crimes. And then if we look at France in particular, the arms companies themselves could be held criminally liable for complicity. And this is following the jurisprudence from the Lafarge case, which states that it's not necessary that a company shares the intent of the main actor committing the crime, as long as it knowingly contributes to its commission. And this is the argument that we have used in a criminal complaint that we filed in France in 2013 against 3 arms companies that allegedly supplied weapons to the Saudi-led coalition. And I really think it's an emerging legal standard, specifically in France, that may have considerable implications on accountability within Europe. And then, yeah, I think there are other more outside the box legal strategies that you could think of. For example, not looking at the arms companies themselves, but looking at the shipping companies that are transporting them via sea, or airlines that may be transporting weapons or components. For example, I just heard about a case that was filed last year by a group of Belgian NGOs, a criminal complaint against an Israeli company that transported ammunition, which is kind of a interesting idea. And then finally, I think over the longer term, something that we're really interested in at ECCHR more broadly, but also within the context of the arms trade, is looking at the accountability of financial actors. So for example, banks, pension funds, export credit agencies, that have so far, I would say, evaded quite a lot of scrutiny and legal accountability for sure. But it's arguably even more important now that we see this sort of shift with investors, including defense companies, in their sustainable funds. So I don't have a legal strategy yet, but I really think those are the types of targets that we could be looking at.
Thank you, Chloe. I was also writing furiously. Is that what you said? Well, thanks so much to the panelists. This was really rich, at least for me. So I hope also it has created some fertile ground for discussion now. We're going to open the Q&A, and we're right on time. So I'm super happy. We have 30 minutes to have a Q&A. So we'll just invite